Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
This is St. Louis on the Air from St. Louis Public Radio.
Welcome to St. Louis on the Air. I'm Sarah Fensky, filling in for Elaine Cha. Last week, a St. Louis city judge took the extraordinary step of blocking the St. Louis Post-Dispatch from publishing a particular story. The paper had obtained a mental health evaluation of the man accused of killing a police officer in the city's Tower Grove South neighborhood in 2020. The court said the paper could not publish a story about the evaluation. Such cases of prior restraint are extremely rare, and that's on orders from no less than the U.S. Supreme Court. So what happened in St. Louis to make a judge take this step? And for that matter, what's happening now at the St. Louis Circuit Attorney's Office? Kim Gardner is gone. Why did she leave 2 weeks earlier than she initially planned? And what's ahead for her replacement, noted local attorney Gabriel Gore? Our legal roundtable has a lot of thoughts on both topics and so much more, so let's get right into it. Today, we're joined by Nicole Gorovksy. She's a former prosecutor in both state and federal court. She practices at Jenkins and Kling PC. Nicole, welcome back.
Thanks for having me.
And also joining us today is Dave Roland. He is the Director of Litigation at the Freedom Center of Missouri. Dave, welcome back.
It's always a pleasure to be here.
And finally, making her legal roundtable debut today is Kalila Jackson. She is the Director of Legal Services and Senior Staff Attorney at the Metropolitan St. Louis Equal Housing Opportunity Council. Kalila, it's so great to have you here.
Thank you for having me, Sarah.
So we have spent lots of time in recent months talking about the troubles at the St. Louis Circuit Attorney's Office under Kim Gardner. And we also talked quite a bit about the quo warranto that was filed by the state attorney general that sought to forcibly remove Gardner from office. Now, Kim Gardner had announced on May 4th that she would resign her post. That was just one day after the Riverfront Times revealed that in addition to her job as circuit attorney, Gardner was enrolled in an advanced nursing program at St. Louis University. Now, Gardner's plan was to leave on June 1st, but Attorney General Andrew Bailey continued the quo warranto case despite Gardner's stated plans to resign. And then suddenly, 2 weeks early, Gardner suddenly announced that she was leaving effective immediately, and this was on May 16th. This happened very suddenly. Nicole, what do you make of this seemingly accelerated goodbye?
I think a few things were going on. I think that there was legislation moving through Jefferson City that was going to potentially join the city and the county for prosecution purposes, and it looked like it may pass. And if you can imagine, that's a big deal for certainly the people of the city of St. Louis because it's somewhat disenfranchising to the voters. And I think she probably considered that pretty heavily and wanted to avoid that. The other thing is, I was sitting here a couple of months ago talking about this quo warranto and saying there's no way they can make it to this legal standard. It's a very heightened standard. But they were closing in. I mean, they were actually gathering more information than I thought, they would, especially with this stuff about Kim Gardner spending part of her time doing nursing school. And I think, they were certainly, and Andrew Bailey wasn't giving up on the quo warranto. And so I think, I think that was all probably in her mind.
So you think as far as the revelation that she's there taking these nursing classes, would that have made it easier for Andrew Bailey to prove this standard that previously all our experts are saying, I don't know, prosecutors have to have some room to maneuver. How can we second guess them on individual cases? This was maybe something different.
Well, so, basically the quo warranto standard is, close to essentially abandonment of office. But this is time spent out of the office and not doing the prosecutor's job. So they were certainly getting much closer.
Dave, what do you make of this timing of Kim Gardner saying, okay, I'm going to take about 4 weeks to wrap things up, and then all of a sudden, 2 weeks later, saying, hey, actually, I'm quitting effective immediately right now. Even Wesley Bell, who she'd sort of tapped to help in this interim role, he didn't know it was happening on the day it happened.
Entirely by surprise. Of course, we don't know exactly what was going on in Ms. Gardner's mind, but I don't think it was a coincidence that not only was the Attorney General's office pressing forward with their action, but that the morning that she made this immediate resignation, they announced that they had had a private investigator following her, that they had seen her at the university where she was taking these classes, that she had been there in the morning, and it happened to have been the very morning that she was supposed to show up, I believe, in Judge Noble's courtroom and respond to a show cause order.
Yeah.
And that she was apparently there at the school for several hours that morning. I count me as one of the people that did not think that the quo warranto action had any legs, but especially when it started coming out about the nursing program that she was in, and the implication became clear that she might have been using time out of her regular working schedule to go to these classes instead of discharging her duties. All of a sudden, I thought there was a very legitimate chance that the Attorney General could meet his burden. So my best guess is that when this information started coming out, when it was clear that the Attorney General might be able to obtain discovery delving into her academic record, I think that that's when she realized that it was in her best interest to go ahead and step down immediately.
And there was a deposition scheduled for that same week where she made this sudden decision to resign. We know Bailey was going to ask her about these nursing classes. We know that state law requires circuit attorneys to, quote, devote their entire time and energy to the discharge of their official duties. Do you think she might have had to plead the fifth if she's in that deposition, if he starts probing into that? I mean,
I don't recall if there's a criminal penalty for failing to devote one's entire effort to discharging their duties, but if there was some sort of a criminal penalty that might attach, even a misdemeanor, then theoretically she might have been able to plead the fifth on that front.
Kalila, I saw you nodding there. Is this potentially something where you think she might have had to do that if that deposition had gone forward?
No, I completely agree with Dave's analysis on that. I also don't know if there was a criminal component. I'm inclined to agree with my esteemed colleague Nicole. I don't think we can discount the impact that the legislature's impending bill would have had not only on the region, but also on places like Kansas City, which Kim certainly would have been familiar with and would have been concerned about. So I think that she might have anticipated that her initial resignation might have calmed the waters.
Yeah.
And when it didn't, they may have forced her hand, and she made the decision, as she said, that's what she said publicly, that she did this to protect the voters. And I'm inclined to agree with that.
So if you have a question or comment about this topic as we're digging into what has happened in the last month at the Circuit Attorney's Office, you can call us at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air. So here, Governor Parson made his pick, and a lot of St. Louis City residents, I count myself among them, people were very concerned about what Governor Parson might do here. And I feel like there was almost an audible sigh of relief at the point when we found out that Governor Parson was trying to choose someone who I feel like he must have felt this was someone that St. Louis voters were going to be okay with. This was not the Josh Hawley's your new circuit attorney, St. Louis. Kalila, what do you make of this choice? Gabriel Gore, a partner at the Dowd Bennett law firm.
Yeah, I think it's a exciting choice. Reverend Gray was interviewed, and I think one of the things that he said, he's a well-known activist in the community, and one of the things that I think we still need to hear is what is going to be Mr. Gabe's view on justice. The reality is that the St. Louis voters voted Kim in not once but twice because she professed and proclaimed that she was going to bring change to this office. And so while I think that Gabe it's an encouraging selection, I think we're still, what I'm still wanting to hear, and I think what the community wants to know, is what is his view of justice? And when he's taking over an office that has been, by all accounts, in shambles for years at this point,
how does he approach that so that justice is done and done swiftly?
Yeah, I mean, this is so different than a normal campaign where we have to hear somebody answer questions about their philosophy about how they'll handle stuff. Whatever assurances he had to be made to Governor Parson, who has a vastly different idea of justice than, say, someone like the Reverend Darrell Gray,
that's right,
who you just mentioned. On top of that, I've heard a lot of people mention he had been a federal prosecutor back in the day. I believe he was with that office for about 3 years before he went to Dowd Bennett. But he has not practiced in circuit court, which is now where he's going to be the boss. Nicole, you have been a prosecutor in both state court and in federal court. Is there a big difference here between the two?
So this is an interesting question because a lot of people have been asking me, is it a big deal that he hasn't practiced in state court? And it's so interesting because I think in a lot of prosecutors' office, when a new person comes in, generally the school of thought is, well, as long as the office has been running smoothly and well, then they're just an administrative person. And, generally the electeds or the new prosecutors that come in, their job is to just sort of not ruin things that have been going on. But this case, it's not an office that has been running smoothly. I still kind of think that the head prosecutor is probably not going to be doing a lot of jury trials himself. And so the fact that he doesn't have jury trial experience in state court is maybe not such a big deal. But he is going to have to do those administrative things and get that office running in compliance with the state court system, which is going to be a significant learning curve for him. So I think a lot of it is going to depend on who he brings in.
And he's going to have to bring in a lot of people. I believe when we last checked in on this, they were down to 2 prosecutors in the violent crimes unit. And St. Louis, say what you will about St. Louis, but there's a large volume that needs to be handled by the violent crimes unit. Kalila, it's also not necessarily easy to find good people these days and to staff up quickly.
Well, no, that's a reality. And as we were discussing before the show, one of the challenges that Kim was facing, there was massive firings and then massive exodus. And the people that came in with that second wave were mostly new attorneys, people straight out of law school. And anyone who's ever had a new attorney knows that that is also a steep learning curve. And it requires a tremendous amount of support and training and senior staff to show people the ropes so that mistakes are not made. And they are going to need staffing at every single level. And one of the things that I've noticed, I've taken a look at some of the job postings, these are relatively low-paying positions comparatively when you're talking about students who have mountains of student loan debt that they are responsible for. And so when you have your choice of competing offers, when you can go do good work, and there's much good work to be done in this city, if you can go do that at a living wage, it's going to be tough, and they've got some challenges to face there.
You say you've looked at these job postings. I mean, what kind of range are we talking for these salaries?
My recollection is that for a starting salary, for a new attorney, you're looking around $50,000, $53,000. And that's very, in this day and age, particularly with student loan debt, that can be prohibitive for people such as myself who came out of law school with student loans, despite, having, scholarships and other things. But these are realities that the people that they are going to be recruiting are facing and looking at in this job market when they can say, I can take this position here, or I can go across the river, or I can go work for legal services. And it's a real reality.
Nicole.
Yeah. So one of the things I was going to say is that the way the circuit attorney's office has, in prior administrations worked is that there's kind of been a high level group of people who were there a really long time. And that experience base was essential and kept the office running. And then they could bring in those younger kids. I'm calling them kids, I apologize. But those younger people at the $50,000 range. And those people would get great instruction from that more experienced base group. Well, those people are gone.
Yeah.
And those people have left. And I can speak from experience as one of the young I'm going to call myself when I was a kid, coming out of law school and, taking one of those jobs that just did not have a very high salary, but it was the best experience in the world, and to learn from those higher level people. And then to know, unfortunately, when I hit the salary cap, I had to move on. And it'll be really interesting to see whether they can get that higher level experience base in.
We want to remind you our phone lines are open. We're at 314-382-8255. Again, that's 382-TALK. I am going to go to the phone lines. Eric is calling from St. Louis. Eric, hi. You're on St. Louis on the Air.
Great to have you back, Sarah. I miss you on a regular basis. This is a great opportunity, I believe, for St. Louis STL Made to really come together behind Attorney Gore, Circuit Attorney Gore. He said he wanted to make this the best office in the country, and we have an opportunity to really come together. As Winston Churchill said, always take advantage of a good crisis. I know firsthand what devastation this caused to our city, because I own real estate and I was dealing with drug people and homeless people. And the police didn't want to really do anything, because when they did do something, people were not pursued and taken to court or justice provided. So this is a great opportunity for our city to come together.
Eric, thank you so much for those thoughts. And it's great to be back. I'm glad that you're tuning in today and joining this conversation. I know there are a lot of people who have a lot of high hopes for Gabe Gore. And certainly, as we've discussed some of what's ahead of him, boy, that's a steep road. There's another question that came in here from Pat calling from South St. Louis. I'm going to squeeze this in before we take our break here. Pat says, it's a relief to see Kim Gardner gone. What should the role of a prosecutor be? Should social change be a part of the prosecutor role? Dave, I'm going to throw this one to you.
I think it absolutely can and should be. I'm among the camp that thinks that criminal justice reform is crucial for our society, especially for our cities. And so I'm hopeful that the new circuit attorney will continue a focus on criminal justice reform while at the same time making sure that people who commit violent offenses are brought to justice. I think that that's also absolutely essential. The biggest thing that I carry away from this whole process is that I was heartened that the governor made a choice that seemed to be broadly accepted within the city. He didn't have to.
Yeah.
The governor had full leeway to put whoever he wanted in that office, and it looked like he really made the effort to find someone that was supported across the board. And I think that is a very powerful thing, a very wise move for him to have made.
We're talking today to our legal roundtable. That is Dave Roland. We're also joined by Kalila Jackson and Nicole Gorovksy. We do need to take a quick break, but we'll be back shortly with our panel. We have much more to discuss. That includes a rare instance of prior restraint against the Post-Dispatch. We're also going to keep those phone lines open. If you have thoughts to share, 314-382-8255, 382-TALK. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
Now, last week, a St. Louis judge blocked the Post-Dispatch from publishing a story. Did you know they could do that? I guess I kind of knew they could do that. I'm still shocked they did it. So the focus of this story was on the man who killed police officer Tamaris Bohannon and then engaged in a 12-hour standoff in the Tower Grove South neighborhood in August of 2020. The Post-Dispatch obtained a mental health evaluation that had erroneously been made publicly available in the court docket. So the reporter contacted the alleged killer's public defender for comment, and instead ended up with a temporary restraining order blocking them from publishing any of these details whatsoever. So this is known as prior restraint. Dave, what makes prior restraint such a big deal?
It's such a big deal because usually if you have a news organization that's interested in publishing something, it is almost by definition something that's in the public interest. they're trying to inform citizens about something that's important in their society. And when the courts or some other government entity steps in and says, no, you are not allowed to share this information, it strikes at the very heart of the First Amendment, which protects not only the freedom of speech, but also, quite pointedly, the freedom of the press. And so to step in before they have an opportunity to share this information with the public and say, you are not permitted to do this, really, it gets, again, at the heart of the First Amendment. And I was dismayed to hear that the judge made this decision in this particular instance.
So I was fairly shocked by this myself, and yet some of the cooler heads around me said, hey, calm down. This is just a temporary restraining order. Nicole, does that make that it's not as high of a standard for the judge to say, hey, you're not allowed to publish this?
So the way that works is you originally file for your temporary restraining order, and the judge has a list of factors that they are supposed to look through and decide, one of which is the likelihood of winning as it goes to a more permanent order. And I think a lot of judges are used to just granting sometimes the temporary order to give themselves time to think about it for the more permanent order. But I think there's a problem with that in this case, which is, newsworthiness has a timeliness element to it. And so I think in this case, that is a much more dangerous stance to take. Whereas in another case, you might say, okay, I'll grant the temporary one and just give myself some time to consider the issues. I think in this case, even granting the temporary one is a much bigger deal.
So my understanding is that why we're even at this point of there being this restraining order is that the public defender is saying, hey, I've got to make sure my client can get a fair trial, that with this out there, this is going to prohibit him from doing that. Kalila, is that a fair thing for the judge to consider here? I mean, once the newspaper publishes this story, you can't put the genie back in the bottle. It's going to be out there.
Certainly not. And to Nicole's point, that's one of the factors that the court would have been looking at when analyzing whether the temporary restraining order should have issued. And so when the Post goes back to court, I believe this has to be briefed. I want to say it's early June 2nd or so. They will have the opportunity to lay out why this is not irreparable harm. And what's interesting is, these are questions that the courts have been dealing with for generations. What is the bound between the right to privacy and the First Amendment, our fundamental right to free speech and freedom of the press?
Dave?
Yeah, so I wanted to step in here a little bit because I really think the question here is whether a fair trial has been imperiled, and what standard does an applicant for a restraining order have to meet in order to suggest that a fair trial is being imperiled. And the U.S. Supreme Court has dealt with this. There was a case back in the 60s where the Supreme Court said, look, you can indeed restrict the publication of information if necessary to protect the right to a fair trial, but, and then they added some very important qualifiers. They said the restriction of speech can't be your first step. You have to evaluate whether there are other measures that could be taken to limit the risk of spoiling a jury. So, for example, you have to consider, well, if this information comes out, could you change the trial's venue so that you could have an unspoiled jury pool? Could you postpone the trial so that kind of the public interest or the public furor would die down in the meantime? Could you filter out potentially biased jurors through voir dire? In other words, the process where you're asking questions of potential jurors. Could you filter them out that way? And then also, you can instruct the jury quite clearly, you're not allowed to consider any of this information that you might have encountered before the trial. You can only consider what's been presented at trial. And it is only after the government has shown evidence, not just argued, not just suggested, but shown evidence that these types of measures would not be sufficient to preserve a fair jury or a fair trial, that you can go to the following step of actually prohibiting publication of information.
Interesting. And I don't see much evidence that has happened yet in this case. Kalila?
Well, Dave, I'm curious of what you would say about the right to privacy that's also running heavy along in this case. I think the public defender's office made the point that there is also information that would ordinarily be protected by HIPAA. And in this case, we also have to consider that the statute in question that allows these mental health assessments or requires these mental health assessments also explicitly makes that information confidential. And so what we have are, it's a dueling standard between what the state has said should be confidential and protected versus what our Constitution says about the right to free press. And so at what point do we balance those interests, and how do we balance it in favor of which? And I think it's a valid question.
The Supreme Court's already addressed this in the Pentagon Papers case. So the Pentagon Papers dealt with information that was absolutely confidential, that people were not supposed to have, according to the government. And yet, because it was obtained by journalists and it was information that was pertinent to a subject of public interest, the Supreme Court said you can't prevent them from sharing this information. Now, I do want to clarify that if someone finds that they have been injured by information that has been shared by a journalist, there may be avenues that they can pursue to recover the damages that they have suffered. But I think that that's the exception rather than the rule. And I do think that that is a much better way of addressing the potential risks than to say we're going to silence a member of the press from sharing information that in this situation was lawfully obtained.
Right.
Like, this is information that they didn't do anything wrong gaining the information. And so frankly, if someone's concerned about the information that might be shared, the better position is to say, well, counter speech, come back and say why you don't think that information is accurate or trustworthy, or you can say, I don't think this isn't anyone's business, but frankly, it's up to the people to make that determination for themselves, not for the courts to interfere.
Nicole?
Yeah, to play off of that a little bit, I think what happened is the Missouri Department of Health filed this report in error. And I think, when you're talking about HIPAA violations and confidentiality and all of that, I think that's the entity that made obviously the massive mistake. And they are also the ones that have the liability for that, especially as they may be considered medical providers and subject to HIPAA. And that's going to be a massive issue. But we are a step removed from that, and the accident happened, and the Post-Dispatch got it. Now we're talking about prior restraint, which has much higher scrutiny. I think we're in a different ballpark.
Do you think in this case, as you said, sometimes the judges might even grant these type of temporary orders by rote, just gives them some time to think about it. When we come back in a week and this is briefed and argued, do you think the judge is going to reverse on this?
I hate to make predictions because I'm always proven wrong, but I do think this is going to get reversed. Yeah.
We will get to see the story. Now, I wonder if the Post-Dispatch then is going to think about this story and go, oh, I don't know. We've got some HIPAA violations here. Do we want to go this far with this? It's going to be interesting to see what kind of story they publish now that we all know some of the backstory. It's also interesting. There's big changes coming to public access for court records. This one was filed in error, but there are going to be a lot more records that as of July 1st, we're supposedly going to be able to see at the same time that the court is pulling back on some other records that people who weren't attorneys like myself used to get access to. They're now saying, hey, things like civil judgments and liens, there might be Social Security numbers in there. We're not going to even let you see these anymore. It seems like kind of this ongoing battle of what should we be allowed to witness. Do you think the court is getting this balance overall, Dave? Do you think they're getting that right in terms of what they allow us to see, what they don't allow us to see? This erroneous document aside.
Well, let me say I was thrilled when I heard that the Missouri Supreme Supreme Court was going to make it easier for citizens to access judicial records. I think that that's quite important. One of the things that we know from the founding era is that exposure to the legal system and the public nature of our legal process was thought of as being an important tool for educating citizens about their society. And so I think that the more transparency we have as to the legal process, the better it is for citizens, especially when we're expected to know what the law is, right?
Right.
And so I think generally speaking, that's a very positive development. I am frustrated that because of some of the hiccups that we have seen along the way, now all of a sudden there's kind of this pushback. But as a almost a transparency absolutist, I think that any steps in the direction of transparency are going to be a net positive. But of course, we do need to make sure that we are respecting the restrictions on certain information. For example, Social Security numbers. That's pretty crucial.
Kalila, I know that you're not a transparency absolutist, that you do take that right to privacy seriously. Do you think the court is at this point getting the balance right between what documents they let non-lawyers like myself see?
I think that I agree with Dave that it is a net positive that there's going to be more information that the public is going to have access to. But I think we also have to acknowledge that that transparency is a double-edged sword for certain populations. So in my world, as a housing attorney, as an anti-discrimination attorney, I am well aware that there are abuses of that system. And right now, the way that our court system is set up, there are not ways to easily protect people when lawsuits that have been filed wrongfully against them. And so, for example, if I'm a day late and $1 short on an eviction and I'm evicted and my landlord reconsiders and decides that case shouldn't have been filed, that's still on my record. And housing providers can see that from now until eternity, and it can be used to bar people from having access to housing unreasonably. And so I do think that there is a certain responsibility that comes with transparency, and what I'd like to see is that the court do these things hand in hand. So it's responsible to make sure that people's Social Security numbers are not being released to widely into the public. But I think there are some additional steps that I'd like to see OSHA and the circuit courts take to protect the public more broadly, particularly when there are cases that should not have ever been filed in the first place, to ease that process so that people are not overburdened and actually harmed by that transparency.
And OSCA, that is, I'm going to get this acronym wrong, but they're the committee that's looking into figuring out how much should be accessible to everybody.
That's correct.
Okay. Nicole?
Yeah, and I come at this from a completely different perspective, from crime victims' rights perspective, and certainly when I had my history of doing clergy abuse cases. And those cases, I mean, attorneys were coming in who worked for these perpetrators and getting entire case files sealed from the public, and that needs to stop. And I think this is hopefully a step in the right direction of that stopping. Now, what I've seen happening on the flip side is that the courts are then pushing back on the attorneys and saying it's now your responsibility to redact the Social Security numbers, to redact, maybe certain addresses, things like that. And so that's going to be a pain in the butt for attorneys. But I do think that's the right way to go.
It's interesting hearing just the three attorneys with us today, how many complicated issues the court has to synthesize when deciding on these levels of access. I don't envy their task on this any more than I envy Gabe Gore's task at the St. Louis Circuit Attorney's Office. We are going to have to take a quick break here. We're talking today to our legal roundtable. That is attorney Nicole Gorovksy. We're also joined by Kalila Jackson and Dave Roland. Coming up next, we're going to talk about a case where two different Missouri moms were sentenced to jail because their kids missed too many days of school. Is that constitutional? This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.
Welcome back. I'm Sarah Fenske. I'm back today for our legal roundtable, and today that includes Dave Roland. He's Director of Litigation at the Freedom Center of Missouri. We're also joined by Kalila Jackson, Director of Legal Services and Senior Staff Attorney at the Metropolitan St. Louis Equal Housing Opportunity Council. And last but never least, Nicole Gorovksy of Jenkins and Kling PC. Now, there's a case that feels like a bit of a shocker for me that I wanted to make sure to talk about today. 2 single moms in Lebanon, Missouri, were sentenced to jail after their kids missed too much school. Caitlin Williams was sentenced to 7 days in jail, had a misdemeanor added to her record. A different judge in Laclede County sentenced Tamara LaRue to 14 days in jail. Now, both of these women appealed. They said the sentences were unconstitutional. Their cases were combined and heard at the Missouri Supreme Court last week. Kalila, do you think they made a strong argument that these sentences should not be allowed to stand?
In my opinion, I think that the court has been trying to identify what does it mean for someone to have a child in regular attendance when the statute is silent on it. And so I thought Flotman, who is representing these plaintiffs or defendants, did an excellent job in laying out where this issue is ripe for confusion, from whether or not this meets the willful standard that the Supreme Court set out in 2005, and whether or not how is a parent to decide whether or not 84% attendance meets the standard of regular attendance versus the 90% that's set out in the handbook. So I think the court is going to have to answer this question going forward, and I think they did a good job setting out the reasons why these parents were almost set up to fail in this instance.
You mentioned this willful standard, the idea that if my kid is not coming to school for a variety of reasons, I might be okay. But if I'm just kind of willfully not taking my kid to school, that's a different matter?
Yeah, and so the Supreme Court set this standard out in 2005 in a case called State v. Self. And what the court said is there's a mens rea, which means that the person or the parent has to be shown that they intended to violate this statute. And so one of the things that the prosecution pointed to is that the district in this case has a handbook, and parents have to acknowledge that the students have to be in attendance 90% of the time. And so what they are using that is to shore up that the parents were sent notices, multiple notices, that their children were not meeting that standard to show to the court that this was a knowing, this wasn't an accidental, that the parents intentionally, for whatever reason, failed to meet the standard that the statute applies. And I think what the defense said is, well, there's ambiguity. There's ambiguity between what the handbook says. They said, in one instance, the parents thought that a child that has a sick excuse, that didn't count towards their excused absences. So it was unclear to them what even counted as an absence that could go towards that percentage.
Yeah, I mean, I was kind of shocked by one of these kids missed 13 days of school. The other missed 15 days. In one case, one of the families had COVID. And at that point, I thought you were supposed to be staying home for at least 10 days. Maybe I'm not up on the latest, but it doesn't seem like a ton of days off, Nicole.
Well, and I'm going to take my lawyer hat off for a minute and talk about how this case really hits me very personally for a couple of reasons. First of all, Sean McElprang was the attorney who argued this for the Attorney General's office. Sean is a lovely guy. He's my old boss. And Ellen Flotman is a person who, when I was at the Attorney General's office, was on the other side of a lot of my cases, and she was a worthy opponent. So, but the more personal level is that this actually happened in my family. We did not actually, get as far as, unfortunately, these parents did. But I have a special needs child, and part of her special needs are extreme school anxiety, extreme social anxiety, and the school was threatening to send my husband and I to truancy court.
Wow.
And there was no doubt they were telling us, on the one hand, you're wonderful parents, you're doing all of the right things, you're getting all the professional help that you need to get. And then on the other hand, they were saying, we have to make this referral because state law tells us we have to. So I find this to be terrifying on a personal level. That's me taking off my lawyer hat. Maybe if it wasn't such a strong feeling in my personal life, I would have a different opinion, although I kind of doubt it. But I do want to say that, there are parents out there who are trying very hard, and this could happen to them, and I think it's terrifying.
Dave, this is, we talk a lot about how Missouri can be an unusual place, and yet my sense is that this is not necessarily unusual that Missouri would allow a parent to be jailed for this. This has happened over time. Have these things been shown to be A-okay?
Well, I mean, courts have generally allowed it. I think one of the most important elements of this, from my perspective, is the trial judge, when he was assessing this, he specifically said, this is a terrible statute.
The trial court judge said that.
The trial,
wow.
But he said, like, my hands are tied. I have to, follow the law here. But the judge specifically said it was awful. And I happen to agree. And I think the question in front of the Missouri Supreme Court is what variety of awful this is. So the issue that the court's really looking at here is whether the statute provides sufficient clarity about what constitutes regular attendance. And that implies that if only the statute was clearer, like if the statute said, well, you have to attend 90% of the school days, that would be somehow okay. I don't think that would be okay. Because parents are almost always in the best situation to understand what their children need on a day-to-day basis, and the idea that the government would establish a standard that basically trumps parental judgment or allows for a series of exceptions that could then be manipulated by parents who have the various types of capital that would allow them to win favor with an administration versus parents who don't have that kind of capital. I think that that's a bad rule. And so my preference is I of course believe that children do need education. I want to see children educated. I think that allowing parents to be thrown in jail if they fail to meet a standard set by the government for school attendance is deeply problematic.
And yet I feel like some of these laws came out of this idea that some kids were maybe being neglected by their parents, that the parents weren't coming through in ways that would give the child a fair shot at life. And it seems like some of these things we go back and forth. We're like, we're doing this to help the kid. And then we're like, wait a minute, jailing the parent doesn't help the kid. There seems to be this push-pull. And maybe we're now at a place where more people are acknowledging exactly that you're saying, Dave. Kalila, I wonder if the court had, I guess, if the Missouri law had a more clear standard, would there be a way that this should still be constitutional and allowed, or should we take this off the books?
I think that the first step is to have clarity in the statute if this is going to exist. And going forward, I think what we have to call on is the legislature to take decisive action to fix this. There need to be clear requirements, but there also need to be reasonable exceptions that allow for parents to do what is in the best interest in their child, and also reflects the reality that there are families without transportation, there are families without means, there are families that have difficulty getting their children just the basics that they need in order to get to school. And the way that this is structured right now, now it is left to the districts wholly up to their discretion, so that Lebanon may have a different practice than Ladue, then may have a different practice than Clayton. And that is exactly what these defendants have said to the court, that we must have some clarity so that there is not these differences within our state if this is to continue.
So I'm actually going to switch to another topic for our final 5 minutes here. I got to talk about artificial intelligence. This is something that is coming for all of us. I think it's coming faster for me than anybody else, and I'm terrified about it. But hey, there's now a lawsuit seeking to block AI. This was filed by the Miller King law firm in Edwardsville, and these lawyers are suing on behalf of lawyers. Go figure. You guys are looking out for each other. They're suing an artificial intelligence-driven service called Do Not Pay. Dave, what's the gist of this case here?
It's fascinating. So the idea of Do Not Pay is that people can sign up for the service, they can subscribe to the service, and they explain what they want to do and what their situation is, and then a large language model, AI, gives them some directions. And it says, well, here's the kind of lawsuit you might want to file. My understanding, which may be incorrect, is that the subscribers would be acting pro se. In other words, they would be taking whatever legal action on their own behalf, simply using the advice and the guidance provided by this AI system. And that makes it somewhat distinct from some of the earlier versions of kind of legal self-help that we've seen. So there have been companies out there, Nolo, and there are a couple of others that would provide forms for people to use if they didn't want to go to an attorney to do some very basic things. In some of those circumstances, the company would actually review documents that the client had brought to them. And at least in Missouri, that was found to be the unauthorized practice of law. So it was okay to provide blank forms that people could then fill out and file for themselves. It was not okay to then provide this review function, because that was seen as providing individualized advice, and that was considered to be the practice of law. What's interesting here is when you're dealing with a large language model AI, there's no human element. You don't have a human that's reviewing someone's circumstances and saying, well, here's what I would suggest. And it's not clear yet what courts are going to do in terms of considering whether this is functionally equivalent to having a very sophisticated Google search where people can do their own research online and then they can take or leave whatever the results they get back are, or whether the courts are going to say, well, no, this is a subscription service that is purporting to provide legal advice, therefore it's not allowed. But the implications are massive. To be clear, I think that AI is not quite ready yet to do the work that lawyers tend to do. There was an example this last week where an attorney basically had ChatGPT prepare a brief that then happened to use cases that the AI system just made up out of thin air.
And the attorney filed this brief?
The attorney filed the brief, and then when the judge said, no, I can't find these cases, you need to provide copies, he had ChatGPT generate the cases.
What is this lawyer trying to get disbarred here?
I don't know if they were trying to, but it's likely to happen. Seriously, the facts are astonishing. Listeners should look it up if they have any interest. But so I don't think that AI is there yet, but I think it's going to be there before long. And then the question is, what do we do where we have laws that prohibit the practice of certain professions that involve providing information and advice, where I think sooner or later we will have software that can provide advice at least as well as humans could? What are the courts going to do with this? Right now, the restrictions on unauthorized practice of professions are pretty strict. The Supreme Court has given some hints that they may crack down on this because it does restrict people from sharing information, and that's a First Amendment issue. But the court hasn't actually directed handled it directly at this point. And so maybe this is the kind of thing that will get the issue in front of the courts and we'll start seeing some decisions on it.
So I got to ask our other two panelists, we just have less than a minute here, but are you more terrified or more excited about these possibilities, Nicole?
I find myself cheering for this lawsuit, but not cheering for the particular plaintiff. I think that the lawyers that are filing it are not going to be the preferred plaintiff. I wish it was somebody who was actually injured by one of these AI systems, because we're not looking out for the legal profession, as much as I would like to. That's not really our job. And, so like I said, I find myself cheering for the case, but a different plaintiff.
Yeah, this is maybe not the case to do it. Clearly, we have just a few seconds left. Excited or terrified?
I'm excited about the possibilities because the reality is that there are many people who do not have access. And so this could increase access to justice for people. So I'm excited.
Well, Kalila Jackson, making her legal roundtable debut, I want to thank you so much for joining us today.
Thank you.
And Dave Roland of Freedom Center, Missouri, thank you.
Always a pleasure.
And Nicole Gorovksy of Jenkins and Kling, thank you.
Great to be here.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Our podcast proudly supports St. Louis artists by using music from Life Creative Group.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations, and leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thank you.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.